Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business lawyer in Massachusetts with over 15 years of experience helping entrepreneurs build, grow, and protect their small businesses. Today we're going to discuss a question I get all the time from Massachusetts business owners. What's the difference between a non-solicitation agreement and a non-competition or non-compete agreement, and which one is better for my business? The question usually comes up in connection with employees, but it can also come up when dealing with independent contractors or other businesses. And the answer is not always clear and has important ramifications for protecting your business and making sure that your confidential and proprietary information is not used by anybody else to harm your business. In this video, I'll talk about the differences between the two types of agreements, what they're used for, and how easy they are to enforce in Massachusetts. If you hire employees, use contractors, or share confidential business information with any other business, this is one episode you'll definitely want to watch until the very end. And please, if you'd like to get more helpful legal tips, hit the like and subscribe button and ring the bell so that you get notified when the next episode drops. It really helps the channel and lets me know that you'd like to receive more helpful business tips like this one. So let's get to it. So let's start with the basics. Non-compete agreements and non-solicitation agreements, or non-compete clauses and non-solicitation clauses, which are pretty much the same thing, are both examples of what are called restrictive covenants. Now you might ask, what's a restrictive covenant? And that's a great question. For simplicity, I'm just going to talk about these agreements in the context of employees, but the same principles apply to anyone, whether it be an independent contractor or another business. A restrictive covenant is an agreement or a clause in a contract that restricts an employee's ability to engage in certain activities while they work for you and after they stop working for you. And there are three main types. The first type of restricted covenant is a non-compete agreement, which restricts the ability of the employee from working for a competitor in a particular geographic area for a set period of time. The second type of restrictive covenant is a non-solicitation agreement, which restricts the employee from soliciting business from your customers or clients for a set duration. A non-solicitation agreement can also restrict the employee from trying to hire away your other employees or getting them to quit for a set period of time. The third type of restrictive covenant is a non-disclosure agreement, which restricts the employee from disclosing or using your confidential and proprietary information for anyone other than your business. I'm not really going to talk too much about non-disclosure agreements today because I've already discussed them in detail in another video. I'll post a link to the video below in the description. However, in order to see how these agreements might work, let's suppose that you own a marketing agency in Boston and your account manager quits. A non-compete agreement or a non-compete clause in their employment contract would prevent your former employee from working for a competitor for a period of time, such as 1 year, in a set geographic location, such as the city of Boston. A non-solicitation agreement or a non-solicitation clause in their employment contract would prevent your former employee from trying to obtain business from your clients or hiring your employees for a period of time, such as 2 years. And a non-disclosure agreement or a non-disclosure clause in their employment contract would prevent your former employee from using or disclosing your confidential and proprietary information after they stop working for you. Now, when you hear about how these restrictive covenants work, you might be thinking it would make sense to have all three clauses or agreements for your employees. And you'd be right. But here's the rub. Individuals have a right to work and earn a livelihood in Massachusetts, and all restrictive covenants are highly disfavored in the Commonwealth of Massachusetts. Massachusetts courts will only enforce restrictive covenants when two conditions are met. First, a business must have a legitimate business interest that they are trying to protect. And second, the restriction must be reasonably necessary to protect that legitimate business interest. One question you might have is, what's a legitimate business interest? And that's a great question. But there's a lot of case law on this issue, and I won't go into all of it here. However, as a general matter, there are really only a few widely recognized legitimate business interests that are worth protecting by a restrictive covenant: business goodwill, trade secrets, and business confidential information. By business goodwill, I'm talking about a business's positive reputation in the eyes of customers that allows it to obtain repeat customers or new customers. And by trade secrets and confidential information, generally speaking, I'm talking about business information that's valuable to the business because it's private and not known to competitors or anybody else. So, for example, if your marketing agency has pricing information, training manuals, and business plans that are valuable and secret, these can qualify as confidential information that your business has a legitimate business interest to protect with a restrictive covenant agreement of some form, so long as the restrictions are reasonably necessary to protect that interest. Now, another question you might have, of course, is what restrictions are reasonably necessary to protect a legitimate business interest? And this is a great question too. Unfortunately, the answer here is also very complicated, and there's a lot of case law on this issue. Generally speaking, however, what is reasonably necessary will depend on a number of factors, such as the type of restriction involved, the business interest you're trying to protect, the people involved, the scope and duration of the restriction, and of course, prior case law. We'll talk about these more in connection with each particular agreement that we're going to discuss today. So let's take a look at non-competition agreements or clauses in a little more detail. Although all restrictive covenants are difficult to enforce, non-compete agreements are by far the most difficult right now. And the reason for this is that Massachusetts recently enacted the Massachusetts Non-Competition Agreement Act, also known as the MNAA, in 2018, and this statute set a lot of requirements and restrictions on non-competition agreements. Here are some of the most important requirements and restrictions created by the MNAA in 2018. First, it applies to non-compete agreements between your business and employees or independent contractors. Second, many types of workers are specifically exempt under the MNAA and can't be subject to non-compete agreements at all. The most notable exemptions are for low-wage workers, which are workers who are non-exempt under the Fair Labor Standards Act. Another exemption is for employees who are terminated without cause or laid off by the employer. Third, any non-compete agreement must be in writing and signed by both parties. Fourth, any non-compete agreement must be provided to the employee at least 10 business days before they start working or before it becomes effective. This means that if you want to hire a new employee and you want them to be subject to a non-compete agreement, you must provide it to that person at least 10 business days before they start working or it becomes effective. Fifth, the non-compete agreement must specifically state that the employee has the right to consult with an attorney prior to signing it. Sixth, the non-compete agreement can't be broader than necessary to protect one or more legitimate business interests that we discussed earlier, such as trade secrets, confidential business information, or goodwill. Seventh, the non-compete agreement must be reasonable in terms of geographic scope and prescribed activities based on the interest that's being protected. This means that your non-compete agreement can't prohibit your former employee from working anywhere in Massachusetts unless the employee actually provided services everywhere in Massachusetts during the last two years of employment with you. This can be a very fact-intensive inquiry, and you need to decide on being as narrow as possible in order to protect whatever legitimate business interest you're trying to protect with a non-compete agreement. Eighth, under the MNAA, the non-compete, generally speaking, can't stop your former employee from working for a competitor for longer than 12 months and should be no longer than necessary to protect your legitimate business interests and having a non-compete agreement. So, if you only need 6 months to protect the goodwill of your business from your former employee, your non-compete should only be for 6 months. Ninth, the non-competition agreement must be supported by, quote, a garden leave clause or other mutually agreed upon consideration between the employer and the employee, end quote. This idea of garden leave or other mutually agreed upon consideration is one of the biggest changes brought about by the MNAA. The idea seems reasonably straightforward, which is that a former employee must be paid something for the period of time he or she is prohibited from working for a competitor. However, to qualify as garden leave under the MNAA, the employee must be paid at least 50% of the employee's highest annualized base salary over the past 2 years for the duration of the non-compete agreement. So, if your non-compete is for 12 months and you're paying the former employee garden leave, you would have to pay the former employee at least 50% of their salary for a period of 12 months. However, it's not clear that you have to pay the former employee this much money in order to support a non-compete agreement, since the MNAA also allows for, quote, other mutually agreed upon consideration, end quote, which could presumably be less money so long as it's in writing in your non-compete agreement and both parties have agreed. However, to my knowledge, there's very little case law interpreting this statutory language, so we'll have to see what happens. And again, the statute was only enacted in 2018, and there hasn't been a lot of cases that have tried to enforce it. So, as you can see, the MNAA imposes a lot of restrictions and requirements on non-compete agreements in Massachusetts. There are 2 key points to note here, however. First, and most important, the MNAA applies to every non-compete agreement signed between an employer and an employee or a business and its independent contractor after October 1st, 2018. And in order for these agreements to be enforceable, they must meet all of the requirements of the MNAA. Failure to meet any of these requirements will make the non-compete agreement absolutely unenforceable, which has been seen in the few court cases which have tried to interpret the MNAA. So if you want to have a new employee sign a non-compete agreement now in 2025, you have to make sure that the non-compete agreement meets absolutely all of the requirements of the MNAA, otherwise it won't be enforced. Second, the MNAA does not apply to non-compete agreements that are signed in any other situation. For example, in the case of a business acquisition, it's very common for the former owner to sign a non-compete agreement, and these agreements do not have to meet the stringent requirements of the MNAA. They still have to be necessary to enforce a legitimate business interest and be reasonable in geographic scope and duration, but courts are much more likely to enforce these types of non-compete agreements when it's between a former business owner and the person who bought the business. Okay, so let's talk about non-solicitation agreements or non-solicitation clauses in employment contracts. As discussed earlier, a non-solicitation agreement or clause doesn't stop someone from working for a competitor, but it restricts that person for a certain period of time from soliciting business from your clients or customers, or from trying to hire away your employees. Generally speaking, there are two main types of non-solicitation agreements. The first type is a client or customer non-solicitation, which restricts the former employee from trying to solicit business from your clients or customers. The second type of non-solicitation agreement, which is sometimes called an anti-rating agreement, restricts the former employee from trying to hire away your employees. These are completely different types of non-solicitation agreements, and you can have one or both types of non-solicitation agreements depending on what your business needs. So to use our marketing agency example, a client non-solicitation agreement would prevent the former account manager from attempting to solicit business from any of your clients or customers for a set period of time. And an employee non-solicitation agreement would restrict the former account manager from attempting to hire any of your employees for a certain period of time. The one you want to use really depends on what your business is and what you're concerned about with respect to your former employees. Now, the good news about any form of non-solicitation agreement is that they are not governed by the Massachusetts Non-Competition Agreement Act, and the MNAA does not apply to any of them. This is specifically stated in the MNAA, and it was recently reiterated by the Massachusetts Supreme Judicial Court, which is the highest court in Massachusetts. This means that you don't have to follow any of the technical requirements for the MNAA. So you don't need to provide them with garden leave, you don't need to provide them with 10 days to review the agreement, and you don't need to tell them in writing that they should get an attorney to review the agreement before they sign it. This is a huge benefit because, as we just saw, the MNAA is very restrictive, and it's going to be very difficult to make sure that you meet all the requirements of it in connection with non-compete agreements. However, even though you don't need to comply with the MNAA, non-solicitation agreements are still restrictive covenants and will only be enforced so long as they're being used to protect a legitimate business interest, and to the extent that the restrictions imposed by the agreement are reasonably necessary to protect that legitimate business interest. With respect to the legitimate business interest, this is usually fairly easy to satisfy for non-solicitation agreements. Most businesses that are using non-solicitation agreements are doing it to protect their goodwill and their confidential information and trade secrets, all of which are legitimate business interests to protect with a restrictive covenant agreement. However, with respect to what is reasonably necessary to protect that interest, this is typically a very fact-intensive exercise, and it will depend on a lot of factors, such as the language of the agreement, the duration of the restriction, the conduct prohibited, the former employee's role in your company, and their role in the new company that they're working for, and various other factors. The only clear-cut guidance that's been offered by courts is that a non-solicitation agreement or clause should not be longer than 2 years, and the shorter the better. With respect to the other factors, it will really depend on the circumstances, and what is reasonably necessary for one business may not be reasonably necessary for another. For example, if you own a small business with 20 clients and 5 employees who are intimately involved in servicing all your clients, what is reasonably necessary to protect your legitimate business interests is completely different from a larger company with thousands of clients and hundreds of employees, many of whom have no customer-facing roles. So, if you want to use a non-solicitation agreement for your employees, speak with a knowledgeable attorney to make sure it's appropriate and it's not broader than what's necessary to protect your legitimate business interest. So you might be wondering, which one is better for your business? A non-compete agreement or a non-solicitation agreement? And unfortunately, there is no one-size-fits-all answer. To determine which one is better for your business, you really need to ask yourself at least 3 questions. First, What legitimate business interests are you trying to protect with a restrictive covenant agreement? As discussed above, there are really only three types of legitimate business interests that can support a restrictive covenant agreement: protection of your goodwill, protection of your confidential information, or protection of your trade secrets. If you don't have any of these legitimate business interests, you can't use any restrictive covenant agreement. Second, after you've identified the legitimate business interest that you're trying to protect, ask yourself, what's reasonably necessary to protect that business interest? Depending on the business interest you've identified in the first question, you're part of the way to determining whether a non-solicitation agreement or a non-compete agreement makes the most sense. For example, if the legitimate business interest that you're trying to protect is your confidential client list that you spent years developing, then a client non-solicitation agreement and a non-disclosure agreement might make the most sense for employees who have client contact. In contrast, if your legitimate interest is to protect a top secret business plan to increase your share of the marketplace, a non-compete agreement might make the most sense for the high-level executive who created the plan or has seen the plan. Third, the next question to ask is, who do I want to sign this restrictive covenant agreement? Most people think that the default answer is that every employee should sign the restrictive covenant agreement. However, that's not always the case, and some restrictive covenant agreements don't make sense for all employees. For example, under the MNAA, non-compete agreements are not enforceable against non-exempt low-wage workers. But you might want to use non-compete agreements for key employees with very specialized knowledge about your business. And client non-solicitation agreements may not make sense for computer programmers with no exposure to client information while working for your company. However, it might make perfect sense to have these same computer programmers sign employee non-solicitation agreements so that they don't solicit employees from your companies when they go work for somebody else. Once you've answered all these questions, you should have a better sense as to which type of restrictive covenant agreement makes sense for your business. Speak with a knowledgeable attorney if you have any questions. And remember that if you want to use a non-compete agreement in Massachusetts, you need to follow all the requirements of the MNAA, including the 10-day notice, the garden leave pay, and many, many others. Missing any step will make the non-compete agreement absolutely unenforceable in Massachusetts. So, to recap, both non-compete and non-solicitation agreements can help protect your Massachusetts business, but they are only enforceable when they are reasonably necessary to protect a legitimate business interest. And if you want to use a non-compete agreement, there are a lot of hoops that need to be followed under the Massachusetts Non-Competition Agreement Act. Also, keep in mind that the law is always changing here. If you'd like help reviewing or drafting a restrictive covenant agreement, or if you just want to make sure that your current agreement complies with Massachusetts law, please feel free to reach out to me at Brawlsaw LLC. My contact information is below. I help business owners across Massachusetts protect their client relationships, confidential information, and other aspects of their business to make sure that the business grows and succeeds. If you found this video helpful, please like, subscribe, and share it with another Massachusetts business owner. And as always, thank you so much for watching Small Business Legal Tips, and I'll see you next time.